Dunn to the stand to allow Dr. Abuso to be in the courtroom to observe it. And obviously, I think a lot of what Ms. Corey was saying goes to the weight and not the admissibility of his opinion and what he considered about the assumptions. Your second issue with the qualifications, Judge, is I've cited several cases out of the first DCA and the Supreme Court that talk about that. Everybody has to be an expert the first time. The fact that he has worked on cases and high-profile cases and shooting cases and wasn't called cannot be looked at as a detriment of why he was not called. It's not like he was called and then disqualified. There's been no testimony that they've tried to get him on as an expert and a court disqualified.
I understand, but he also said, Mr. Stroller, he's never worked on a case like this.
Well, I think he did say he was involved in a high-profile shooting case when you were asking him about similar cases. I think you said, have you ever testified? And he said no. And that, I was trying to show that he has never been called to testify. I don't think he could be faulted. Had he said, I was called, they wouldn't let me testify, I was disqualified, then I agree with Your Honor, then I would be concerned about his qualifications. I just wanted to clear that up for the record about that colloquy back and forth, Judge.
Well, maybe we might need to clear that up.
Judge, and the third one is, I think it's completely different from the case that you cited for the stand your ground. We are not here to have him say to the jury, because of the way he acted, he was justified in the shooting, it was stand your ground. I even said I want to stay far away from that because I don't want to impede on that jury. And I just want to tell the court, respectfully, I don't consider it a collateral matter, and this is why. I filed the motion in limine intentionally to prohibit the state from talking about everything that happened after what he was indicted for. Your Honor heard argument in case law. Your Honor denied that motion and allowed the state to go into it. This is now my case in chief. Part of the defendant's case in chief is to rebut things that were said and made and argued by the state in their case in chief. So it's not like I'm bringing in a new theory or principle. It was specifically because a motion in limine was denied, Judge. And I have no objection to putting Michael Dunn on first, but I would ask that Dr. Abuse be allowed. And I believe I gave you the case law yesterday, which talks about, it's Allen v. State, 365 Southern 2nd, 456. Says there must always be a first time for everyone, and extensive education is not necessarily a prerequisite to expertise. In order to qualify as an expert witness, one needs only to have an acquired such a special knowledge of the subject matter of his testimony, either by study or by practical experience. There's Rose, that was a first DCA case. Rose v. State, 506 Southern 2nd, 467, also first DCA judge. Humble v. State, 652 Southern 2nd, 1213, Florida first DCA. That was a murder case, talks about exactly this. And that talked about post-traumatic stress disorder, and I used it to show that we're not using it for post-traumatic stress disorder. And that issue was a battered spouse syndrome, and back then it was a fairly new concept, and Dr. Abuso testified that this has been around since World War I, really hit the ground in the 70s. He did his own research in the 80s and so on and so forth. I did cite State v. Mizzle, the M-I-Z-E-L-L judge, and that actually gives the 5 kind of prong test I would talk to about it, Your Honor. And I think Dr. Abuso's expertise, training, and experience satisfies that prong test, also first DCA. And the last one, Judge, is Conley v. State, C-O-N-L-E-Y, 39, Florida Law Weekly, D24, first DCA 2013, which basically said Fry doesn't exist unless it's new or novel. It's the Daubert, which you mentioned yesterday, Judge, because I think Ms. Corey had said brought up Fry, but again, this is not a new or novel idea. It's not a new or novel theory. It's twice.
I'm with you. It's you know, apparently if it's mentioned in the I've forgotten what the name of the book is, DMS 4 or 5, whatever we're on, if it's mentioned in there, I take his word for it.
And then
it's not some new science. I agree with that.
Judge, in Chavez v. State, which I believe is Florida Supreme Court from 2009, talks about an expert can be qualified through knowledge, training, or education, and it's not just limited to academic, scientific, or technical knowledge. An expert may acquire the specialized knowledge through an occupation or business or frequent interaction with the subject matter. So that's the predicate that I laid, Judge.
I understand.
Okay, and I do believe I gave Your Honor that case law yesterday.
Okay. Well, I'll let the state huddle a little bit, see what tact they want to take. So we'll be in recess for 20 minutes.
Judge, do you want me to put his deposition in your